Hello, listeners. This is Born Curious, a podcast that celebrates the unbounded curiosity that defines our home here at Harvard Radcliffe Institute. I'm your co-host, Heather Min.
And I'm your co-host, Ivelisse Estrada. Today, we're sharing another one of the moving lightning talks that were delivered at the Institute's 25th anniversary celebration.
As you may recall, each of these talks is a standalone jewel on a broad topic, delivered in 7 minutes by an expert in the field. I refer to these mini releases as fun-sized episodes. Our second of these mini podcast releases is Nikolas Bowie on the topic of justice.
Nikolas Bowie is the Louis D. Brandeis Professor of Law at Harvard Law School and the 2024 to 2025 Shutzer Fellow here at Radcliffe. He is a historian who teaches constitutional law and local government law. His research focuses on critical legal histories of democracy in the United States.
It is worth noting that the 2021 graduating class at Harvard Law School awarded Bowie that year's Sachs Friend Award for teaching excellence. I think that the next 7 minutes will make the reasons for that award clear. Let's listen in.
In January 1861, Representative Thomas Corwin of Ohio proposed a 13th Amendment to the Constitution. South Carolina had recently seceded from the Union, and Corwin wanted to persuade other southern states not to follow. The amendment read, in full, "No amendment shall be made to the Constitution which will authorize or give to Congress the power to abolish or interfere within any state with the domestic institutions thereof, including that of persons held to labor or service by the laws of said state." In other words, no future amendment to the Constitution could permit Congress to interfere with slavery. By March 1861, both houses of Congress passed the amendment. In his inaugural address, the new president, Abraham Lincoln, endorsed it. States like Ohio and Kentucky soon ratified the amendment. The only thing that prevented it from becoming part of the Constitution was the North's victory in the Civil War. It isn't difficult to imagine our Constitution today with the Corwin Amendment part of it, an amendment permanently prohibiting Congress not only from interfering with slavery, but also from regulating other domestic institutions like child labor, minimum wages, and employment discrimination. Consider what you would do if you were born in this country where such a provision could not be amended away. Would you consider it just to comply with such a provision if it were part of our Constitution? I think not, for a few reasons. First, I would object to the provision's content. Slavery is wrong. A rule that protects slavery would also be wrong. Second, I would object that I had no say in making this sort of provision. I don't mean that just in the sense that the provision was drafted and voted upon entirely by white men in 1861. I also mean that all of those white men are dead. They died decades before any of us were born. Who are they to tell us whether we are allowed to have a Civil Rights Act or Title IX? How just is it to be governed by a group of people whom we can never hold accountable or even talk to? And that raises a final objection. I think the most pernicious aspect of the Corwin Amendment is that it would not only prevent us from abolishing slavery, but also make it impossible for us to amend the provision itself. The framers of the provision were so committed to their own sense of morality that they didn't worry about the profound injustice of binding future generations permanently. These considerations about the injustice of the Corwin Amendment might not seem to matter much because it was not, in fact, ratified. But the reason I bring it up today is because those same three injustices, what it says, who voted on it, and how it can be changed, are applicable to the Constitution we have actually inherited. One reason why Lincoln and others endorsed the Corwin Amendment in 1861 is because they believed the existing Constitution already prohibited Congress from abolishing slavery. The Supreme Court, in a case called Dred Scott, had even declared that the Constitution banned Congress from limiting the spread of slavery to new territories. And that interpretation was not terribly surprising because the original Constitution, like the Corwin Amendment, was written and voted upon exclusively by white men who had long ago died. Only 55 men participated in the drafting of the US Constitution. Half of those 55 men owned slaves, and only about 2,000 additional men in the 13 states voted on their work. The Constitution these men drafted and ratified protected not only slavery, but many other injustices too. It has been invoked to sanction the genocide of Native Americans, the exclusion of Chinese immigrants, the disenfranchisement of women, the internment of US citizens, and a decades-long totalitarian system of racial segregation enforced by violence and voter suppression. The Constitution that we have is also one of the most difficult to amend national constitutions in the world. Like the Corwin Amendment, some provisions of the Constitution explicitly prohibit us, our own generation, from amending things like the Senate's violation of the principle of one person, one vote. The rest of the Constitution can be amended only if a supermajority in the House, a supermajority in the Senate, and supermajorities in the state houses and state senates of 38 states all agree on the change. No other country has anything like this. And to me, this entrenchment is profoundly unjust. Now, many people over the years have recognized the injustice of making laws nearly impossible to amend or get rid of. Thomas Jefferson complained early on that a perpetual constitution would make the earth belong to the tyranny of the dead. He believed all constitutions should expire after not 25 years, but 19 years, so that every generation would have the same right as his to decide whether they liked the existing system or whether they had suggestions for improvement. It took some time, but Abraham Lincoln's generation recognized this too. Despite beginning the Civil War by endorsing the Corwin Amendment, they spent the war reinterpreting the Constitution as something whose words could be updated through democratic politics. Even before proposing new constitutional amendments, Lincoln signed ordinary laws passed by Congress that began to abolish slavery and reconstruct the Union into a multiracial democracy. The Reconstruction Congress rejected the Supreme Court's calcified invocation of history and tradition. Instead, they used statutes to expand the Constitution into the basis for a government of the people. I think their experience offers an important lesson for our generation today. As just as you might think a constitution or amendment might be, it is unjust to bind generations after you without allowing them to decide for themselves what laws they want. Unless our fundamental laws are as easy to amend as our ordinary statutes, we will be shackled by the values of the past. So rather than allow ourselves to be ruled by the hands of the dead, or even by the hands of robed lawyers who claim special powers to commune with their original understanding, justice demands that our elected leaders take ownership of the Constitution on behalf of we, the living people.
That concludes today's program.
Born Curious is brought to you by Harvard Radcliffe Institute. Our producer is Alan Grazioso. Kevin Grady, Anna Song, Productions, Inc.,
And Cabin 3 Media provided editing and production support.
Many thanks to Jane Huber for editorial support.
And we are your co-hosts. I'm Heather Min.
And I'm Ivelisse Estrada.
Our website where you can listen to all our episodes is radcliffe.harvard.edu/borncurious. If you have feedback, you can email us at info@radcliffe.harvard.edu.
You can follow Harvard Radcliffe Institute on Blue Sky, Facebook, Instagram, LinkedIn, and Threads. And as always, you can find Born Curious wherever you listen to podcasts. Thanks for learning with us.
And join us next time.